Good morning, everyone. My name is Chris Morgan. I'm an attorney up at Barran Liebman in Portland. I've talked with you all a little bit before about some COVID-19 considerations, what we need to be doing as employers to keep our workplaces safe, healthy, comfortable places to be, not only for our employees, but for our customers as well, particularly with places of public accommodation, things like that. So today we're going to jump into a little bit more content. We're going to talk more in depth about Form I-9s, what the notice of inspection and audit process looks like, and some of the really easy ways that we can audit Form I-9s to make sure that we're in compliance and that we're prepared in the event of an ICE audit. We're also going to talk about telecommuting policies and why it's super important to have a comprehensive telecommuting policy in place right now. If you have a majority or even some of the workplace that is working remotely, there's a lot of smaller issues that go along with that in terms of how much am I paying people, am I limiting the work environment to a space that I'm comfortable with, so I'm not, giving rise to unneeded concerns with respect to workers' comp, etc. We're also going to talk about workplace accommodations. And this is particularly important, probably the most complicated subject that we'll talk about today because it really is a fact-intensive inquiry. But what we're going to go through is sort of the distinction between the ADA, the FFCRA, protected leave, non-protected leave, and some of the options that I have as an employer to provide accommodations for my employees, but also if I have an employee who's refusing to come back to work, what are my options in that scenario in terms of making sure that they're accountable and that I'm also meeting my objectives as a business owner or as a manager. A couple of COVID-19 related reminders that I want everyone sort of to be thinking about. Number one thing, right, and this is with sort of the overarching idea of we're trying to create a safe work environment. We're also trying to mitigate risk to the extent possible, right? And the number one thing there is to encourage employees who are sick to stay home. I think a lot more of this is common sense than perhaps we realize. I think we tend to make it maybe a little too complicated, but this is a good idea, not only so long as sort of COVID-19 is in the forefront of our minds, but as a general employment consideration moving forward. If an employee doesn't feel well and if an employee is sick, encourage them to stay home. One thing that we can do, and we talked about this a little bit last time, we have the availability as an employer to create sort of a daily health check sign-in sheet certification. And what that's going to look like is essentially an employee comes in and at the beginning of their shift or at the beginning of their workday, they certify on a piece of paper that they have a temperature that's below 100.3 degrees. You can even provide a thermometer in which they can take their temperature right there on the spot, and that they're not experiencing any symptoms of COVID-19, have not been around anyone who has COVID-19 in the last period of time. That's an option that I'm encouraging people to use right now, again, with this overarching idea that we're attempting to the extent possible to mitigate risk and to keep our work environments safe. Next thing I want to remind you about is we need to be monitoring absenteeism and have flexible time off policies to the extent possible. We're going to talk more in depth about what accommodations look like when they need to be given, when they can be given, even if you're not required to under the law. But it's a good time to sort of think about what does our absenteeism policy look like? What does our time off policy look like? Do I have a time off policy that coincides or is in conjunction with Oregon paid sick time, etc.? So those are three key things there as well. A few more. I want people to have an action plan if someone does report an infection. All of that needs to be confidential in terms of who actually contracted COVID-19. But it's something you're probably going to want to alert other people in that immediate workplace or facility about. And people really should have an action plan in place for what that's going to look like. Next, create and test emergency communication channels. Do I have a way to communicate with my employees effectively if we need to close quickly or what have you? Do we have a way to efficiently and remotely communicate with our employees? Last but not least, establish communication channels to the extent possible with state and local authorities. These are the people who are setting and dictating policy within the state, And I think a lot of them are receptive to having conversations about what this is going to look like or what that's going to look like with respect to your specific work environment. And I'd encourage you to sort of open those channels of communication to the extent that you can. And I think through that process, you're going to be able to build relationships and pull some great information out of that as well. Wanted to note some free tools. If you don't have these already, these are going to be included as handouts along with this presentation. We're going to have a return to the office COVID-19 employee self-certification. So this is the form that I was talking about before, where essentially employees come in and they self-certify that they're not experiencing symptoms, that they have a temperature that's below a certain level, etc. We're going to include that as well. A flowchart to assist you with processing responses from employees and to determine whether paid leave, for example, might be necessary or applicable under the circumstances. And we're also going to include a sign-in sheet along with the certification, which are going to be two separate documents. And then we're going to talk about this more in depth later, but we'll provide you with a sample telecommute policy as well. So, jumping right into a huge topic right now, I know as sort of a management side advisor when it comes to HR and employment related issues, this is something that we're seeing on almost a daily basis, and this has to do with virus related accommodations. So specifically with respect to COVID-19, there's been a lot of questions about what state or federal laws are implicated that may dictate the way that I need to treat a specific time off request or a specific request for an accommodation. Part of that is understanding and using knowledge that you already have as an employer to dictate your next steps. So my first bullet point here, as you'll see, is an employer may initiate the interactive process and ask employees with known disabilities to request accommodations when the workplace reopens. And so a question that I've been getting frequently is, hey, we know we have an employee who is in an at-risk age group, for example, 65 plus is what the CDC and the health authorities are telling us at this point is an at-risk age group. We know we have employees in that age category. We know we have employees with underlying health conditions, which might exacerbate or complicate health situation if someone were to contract COVID-19. Do I have to wait for them to reach out to me, or can I reach out to them and say, hey, are you comfortable coming back to work? And if so, are there any accommodations that we can put in place for you above and beyond our normal safety and sanitation procedures that might be necessary under the circumstances? And the answer is absolutely yes. Keeping in mind that this information should not be shared with other people and that it should be confidential to the extent possible, you can certainly reach out to employees that you may have accommodated in the past or employees that you know have those underlying health conditions and ask them about next steps and if there's anything that you can do to help them out. Requests to continue teleworking are not necessarily a bad thing. This is about as easy as it gets in terms of an accommodation. If you're in a situation where an employee can successfully work from home, you don't have issues or concerns necessarily with their productivity, allowing them to continue to work from home for a period of time should not be any big deal. Now, if you do have issues with their productivity and they may be at home and you're not comfortable with their work output and what's been happening, there's some avenues there. And just because someone is working from home on a temporary basis does not necessarily mean that they have the right to an accommodation under the ADA. And there's a couple of different considerations that we're going to talk about with respect to that as well. On to those next couple bullet points here. To that point on the ADA, what we need to be thinking about is a threshold question. Is this, to the extent that I get a request for accommodation from one of my employees, is this a request for reasonable accommodation under the ADA? Or is it just a request for reasonable accommodation? There is a significant difference, not necessarily from a practical standpoint, but from a legal standpoint, there's significant differences between an accommodation that I make sort of out of the goodness of my heart, so to speak, and an accommodation that I'm required to make under federal law under the Americans with Disabilities Act. Last thing I want to note here, absences due to daycare and school closures do remain protected. So under the Families First Coronavirus Response Act, the FFCRA, one of the qualifying reasons for leave is that I'm unable to work from home and I'm unable to come into work as a result of having to stay home because of the closure of my child's daycare or school, whatever it may be. In that instance, the FFCRA, given that it's going to be in place, it's not set to sunset until the end of 2020, that still is going to be a qualifying reason for leave under the FFCRA for the rest of the year. So keep that in mind, that even as things start to reopen and sort of get back to normal, that those absences are likely still going to be protected. Okay. Wanted to talk more specifically real quick about this distinction between an accommodation that I might make for an employee that is not covered under the ADA and one that is covered under the ADA. So typically under the ADA, you have to have a qualifying health condition. If you have a qualifying health condition and you're considered a qualifying employee, you're entitled to an accommodation that would allow you to perform the essential functions of your position. And that's what we always talk about when we think about the interactive process. The interactive process is always tough because it's non-exhaustive. I have a duty under the law to engage with an employee in a back and forth collaborative process to determine what, if any, accommodations might allow them to perform those essential functions. The threshold question, though, and where I sort of want to make sure that we don't get caught up and that we back up a little bit, is the threshold question of whether or not COVID-19 in and of itself is a qualifying health condition under the ADA. Where we start with that is the idea that temporary conditions that are minor, I'm not saying anything is minor or not minor, it's a case-specific inquiry, temporary conditions that are minor do not qualify as disabilities under the ADA. So when we think traditionally about cold or even the flu, and again, this is a case-by-case inquiry, things that are typically temporary, not ongoing health concerns, are likely not protected under the ADA. It could be in some circumstances, could not be under others, but from what we've seen so far, and in case studies that we've seen, most individuals who contract COVID-19 likely do not qualify for protection under the ADA because it's not going to be a qualifying health condition. That's not to say that you can't accommodate them. In fact, you probably should accommodate them. It's to say that this would not be a ADA qualifying leave, and the ADA, of course, carries with it certain job protections that are separate and distinct from a typical leave of absence or accommodation that I might be giving an employee otherwise. Now, with that said, individuals with certain pre-existing conditions or disabilities, we know that they're at a higher risk for complications if they get the virus. So in that particular instance, if I have an employee, for example, who is 70 years old and has chronic, lung condition, it very well may be that if that person were to contract COVID-19 or even separately has this ongoing chronic health condition, that's going to be a qualifying disability under the ADA to which you have a statutory duty under federal law to accommodate. This distinction, again, is super important to think about because the ADA carries with it certain job protections and employee protections that are not otherwise available. And so before we jump into all of the formal accommodation process under the ADA, the point being we just need to step back a little bit and think about, okay, is this really, in this case-specific situation, a qualifying disability under the ADA? Okay, jumping forward to a big question, and if I had to sort of boil down the biggest question, the most prevalent question that I've gotten over the last several weeks, it's what do I do if I am reopening and I have employees who are refusing to come back to work? It's a huge issue. It's happening for a number of reasons. Some of them are based on safety. Some of them are based on the fact that a lot of employees are making more on unemployment insurance than they otherwise would be at work. And so that's complicated, right? And I think we're thinking of different ways to try and incentivize employees to come back. Ultimately, people are not going to be able to stay on unemployment insurance forever. In fact, if there is a job available for them and they're refusing to come back, technically they should not be eligible for unemployment. But with the backlogs and some of the complications that we've seen with the unemployment department, it's quite possible that those claims could continue to go through and that people are going to roll the dice on just staying out another couple months and seeing if those payments come through. So that's kind of an HR related concern. From a legal liability standpoint, I want people to go through this checklist that we have here to determine what, if any, recourse you have against an employee who is refusing to come back to work. So the first question being, is this work permitted under federal, state, and local guidelines? This really has to do with the industry-specific guidelines, right? So, for example, as of today, a restaurant is able to be open here in Salem that is not able to be open where I live in Portland. So, depending upon where you're at, am I able, under the industry-specific standards and the county-by-county approval, to even operate the type of business? Right? Is my work permitted under federal, state, and local guidelines? If not, inquiry ends there. Second, are we in compliance with all general and industry-specific guidelines? Here's sort of a key part and where I think a lot of the argument is going to be with respect to employees who don't want to come back and are clashing with management over these things, right? Did you follow all of the guidelines, all of the information, health information that we have to date in terms of putting together a comprehensive safety and sanitation plan to say, look, we've done everything that we can do. We have provided every safety precaution that's recommended under the law. We can't do anymore. Are you coming back or are you not coming back? If you cannot say with certainty that you have done everything that you can do in line with these industry-specific guidelines, that's going to complicate this. And the first step before pushing back on an employee who doesn't want to come back is to improve those safety and sanitation procedures so that you can say, hey, we've done everything. Next, I want you to think about sort of, does the Families First Coronavirus Response Act apply? And the importance of that is if I have an employee who's refusing to come back, they may be out for a protected reason. So there's sort of two parts of the Coronavirus Response Act, Families First Coronavirus Response Act. The first one being expansion of the Federal Family Leave Act to include as a qualifying reason a child who has a school that's not open or a daycare that's not open. If the parent has to stay home with that child, that's going to be a qualifying reason. And so if that's the reason they're not coming back, that's legitimate and that's not likely something that you're going to be able to discipline or terminate them on the basis of them, not coming back to work. The second part of it is the paid sick leave. And this is an expansion and in addition to Oregon's paid sick time. But essentially what the federal law does here is sets out 6 different reasons. Essentially they're qualifying reasons for an employee being out. So an example of that would be that they're seeking treatment, they're experiencing symptoms of COVID-19 and they're seeking a medical diagnosis. That is a qualifying reason for being out. If one of those qualifying reasons applies, you do not want to take adverse action against an employee who's refusing to come back because that's going to get you into some hot water for retaliation and all sorts of other things. So consider the Families First Coronavirus Response Act to see if any of those absences are applicable and provide the employee protections before you take adverse action against them. Next, does the ADA apply? Right, because if I have someone who's refusing to come back to work because they have a qualifying health condition under the ADA, and as an accommodation, I have granted them telework, or they have asked to telework, or something else, they have certain job protections to where if you were to terminate them, for example, for refusing to come back to work when simultaneously they have a qualifying disability under the ADA, it's illegal. It's not good. Someone's going to sue you for ADA retaliation and all those sorts of things, which is exactly what we want to avoid. So consider if any of these absences are protected under these federal statutes, state statutes as well, before taking disciplinary action against an employee. Do other state or federal sick or medical leave laws apply, right? Is OFLA applicable under the circumstances? That may not be paid, right? But it nonetheless provides job protections for an employee. So if they're on OFLA leave, you're not going to want to take disciplinary action against them. Is an imminent danger present as defined by OSHA? With respect to COVID-19, and again, this is a very factual, specific inquiry to each working environment, but the answer almost all of the time is that COVID-19 is not going to present an imminent danger in the workplace as defined under OSHA. If it does, we're probably not going to want to take adverse action against someone if they're refusing to come back. If you run through this checklist, if you run through all of these things with the overarching idea that I want to make sure that this person's absence and their refusal to come back into work is not otherwise protected by some state or federal statute, then I feel much better about you being able to take disciplinary action up to and including termination against someone who simply is just refusing to come back to work. But we need to be super cautious about that, making sure that our work environments are safe, our sanitation procedures are where they need to be, that this person isn't claiming that they're out on protected leave for a particular reason. All of those criteria, all of those checklists need to be gone through before you sort of move to terminate. Now, the unfortunate part, even if you were at the end of this process to discipline or terminate someone on the basis that they refuse to come back to work, you did everything right. We take this to trial, and I sit down with you and I say, look, 99%, we take this to trial, we're going to win. It's not going to stop someone from filing a claim against you. It's just the way, unfortunately, that it works. There's a risk that arises with every employment action that's taken. The best course of action, right, is to make sure that we're mitigating risk to the extent possible. And in this sort of time of COVID-19, the way to do that is to make sure that our policies and procedures are as solid as they can possibly be. And as I always say, you want to do this in a way that is nice, right? You want to be kind. I always say kindness at some level ends up mitigating the risk that someone is going to file a lawsuit against you, because disgruntled, angry employees file lawsuits, not people that have been treated well. So that's just a side tidbit right there that you can take moving forward that kind of applies to everything. Okay. One more quick note on the OSHA imminent danger test, because really what we're looking at in terms of what our potential liability could be in the event that our safety and sanitation procedures are not where they need to be. There could be OSHA complaints, and then we have employee complaints for discrimination, disability discrimination, those sorts of things, right? Employees are only entitled to refuse to come into work if they believe that they are in imminent danger. Now, most working conditions in Oregon do not meet the elements required for an employee to refuse to work. And currently, this is as of today, the risk is assessed as relatively low. So it's almost surely not rising at this point to what would be considered imminent danger under OSHA. And I think the importance of sort of knowing that there is this sort of separate test under OSHA is that if an employee does come to you and say, you know, use language like, I'm in imminent danger here, you can remember, wait, I thought Chris told me that this probably does not count as imminent danger under OSHA. Maybe this person is just trying to pull one over on me, right? I want you to think and remember that if someone is coming to you with that language. Now, as is true with all of this, right, special considerations should be taken for employees required to travel to affected areas and healthcare workers as well. So this assessment may be different, rightfully so, in hospitals or clinics or different places where there is a higher susceptibility to infection, for example, or if, for example, say that there's a breakout of some sort at an isolated facility, and I am called in as a sanitation worker or something like that to that facility to help sanitize and do some other things. We're sort of in a different ballgame there, right? So all of this needs to be taken and considered on a case-by-case basis. but they all are considerations that need to be thought out so that we can, ultimately mitigate risk to the extent possible. Speaking specifically about workers' compensation. So there's a lot of debate going back and forth on this right now, but where we sit as of today is that workers' comp, so this is for employees that say, hey, I contracted COVID-19 and I think this is a compensable injury for purposes of workers' comp, that it may potentially be available for employees who can prove that they contracted COVID-19 due to workplace exposure. Now, most of the time, with respect to a workplace injury, we would almost think that the standard that is now being considered would be absurd, right? We need some sort of causation. There's, case after case after case that is spoken to what is considered a compensable injury for purposes of workers' comp. Typically, it requires a showing, right, that this was done within the scope of my job duties, this occurred at my workplace, for example. Some of the proposals on the table right now would essentially eliminate the causation factor, and an employee would just presume to have gotten COVID-19 at work as opposed to actually having to prove anything. So there's a lot of fight going back and forth on that right now, so stay tuned, because once we do have anything definitive on that, or if any standards with respect to compensability change that you need to know about, we'll be on top of that and make sure that you get the information as soon as we have it. If community-based exposures become commonplace, then the causal link between work exposure and the contraction of the virus would probably weaken. So that's just a healthcare consideration there. Take it for what it will, or what you may. But as soon as anything changes with respect to compensability of workers' comp injuries and your premiums, those are really the employer considerations here, in addition, of course, to sanitation and safety. But as soon as anything changes on this, if it does, we'll make sure that we're updating you. Okay, so I want to talk specifically about telework policies, because the majority of people at this point across the state, to the extent that they can, are working from home. And teleworking really is the easiest accommodation that one can give, so long as you're comfortable with this person's work, so long as you don't have considerations, that are getting in the way with respect to productivity and all of those things. However, a good telework policy is really undervalued generally. I would say most people have a telework or remote work policy, but it's only like a paragraph maybe, and it's not actually a signed form or any agreement that's come to. So I'm hoping with this session in the next 10, 15 minutes or so that we can walk through sort of the reasons why a comprehensive telework, remote work policy is important, but also what one looks like. And again, we're going to give you an example that you can take back and you can use, and that you can sort of fine-tune and customize for your workplace. So these here are some key considerations for any telecommuting policy, specifically right now with respect to COVID-19. Right now, the telecommuting policy, and if you have one in place and you need to amend it, that's totally fine. You can amend these things as often as you want to. A good telecommuting policy right now should acknowledge and take into account COVID-19 considerations. So, for example, it might say something to the effect of, the fact that we are granting you telework at this particular moment as a result of, COVID-19 should not be construed as some sort of promise that telework will be available at any given time in the future, and we have the right to pull or rescind this arrangement at any time. Right? What we don't want to do is create this perpetual expectation, unless you want to, and some employers frankly are going completely remote after this, and that's totally fine. But if that's not what you want to do, we don't want to create this implication that, hey, perpetually moving forward, you can work remotely whenever you want. And that's not people's intention most of the time, but we should make that clear. If an employee can work from home remotely, and this is for the time being, consider allowing them to work remotely for the foreseeable future, particularly if they have raised concerns about returning to the office. There's a couple different things here to unpack. First of all, this is just a good idea. for health reasons. There's a wide spectrum of how people feel about all of this. But if there are people who are raising concerns and really don't feel safe coming back in, and they can otherwise perform their job at home and you don't have any concerns about that, there's really no harm in allowing them to work from home for the foreseeable future if it makes them feel better and it doesn't really have any impact on productivity or any impact on you. Second of all, if people have raised concerns, safety concerns about returning to the office, this is the secondary part about liability. I feel like, once you do this sort of for a certain amount of time, you figure out what kind of people are inclined to sue people and those who aren't. A lot of time the people who are inclined to try and sue you for something or file a bully complaint or file an OSHA complaint or whatever it may be are people who have planted concerns previously, because part of them making their case down the road, and if a plaintiff's attorney is advising on this, for example, they're going to tell them to raise certain concerns, to do it in writing, etc. If you're receiving repeated concerns about workplace safety from a particular employee, your antenna sort of needs to go up in terms of, hey, maybe this person is sort of, getting ready to do something here. That's not to say that they don't have legitimate health and safety concerns or considerations. Both can coexist with each other. But if someone is continuing to raise concerns, you probably need to err on the side of accommodation for liability purposes as opposed to, pushing back really hard on it. It's just a smart thing to do from a liability perspective, especially if there's no other concerns or considerations with respect to productivity. Next, we want to consider new productivity standards to the extent that we need to. One of the biggest pushbacks I get from employers, and rightfully so, when I talk to them about what a telework or telecommuting policy would look like for them is, hey, I would be fine with these people working from home so long as they were actually doing their job, right? I mean, the reality of it is, and this is why a lot of employers for decades have not been inclined to just grant this, perpetual pass to work from home, is because there's evidence to some extent that people do not get as much work done from home. Like, could be because they don't feel like it. It could be because there's distractions. There's tons of things that go into it. With that said, that doesn't mean that if you are allowed or are allowing people to work from home that you can't alter the way that their job is done in order to check in with them more and make sure that they're doing what they're doing. An example I'd like to give is maybe if I typically check in with an employee once every month on certain sales goals or certain productivity goals, maybe I make that once a week. Maybe I make that once every 2 weeks. There are certain productivity standards that you can put in place that meet the goals of, one, accommodating a work from home arrangement, but two, also accommodating your legitimate business need to have that person be productive from home. Next, we want to acknowledge non-exempt issues related to pay and physical locations. This is a huge one. One of the things I really try and do in terms of proactive education and limiting liability to the extent possible is to avoid wage and hour claims. There are so many very particular laws with respect to wages, overtime, daily overtime, and the fact that the minimum wage around the state is different per region complicates this analysis. And with telework arrangements, this is something you're going to want to have in here, because here's the rules here as I've sort of spelled it out. Oregon employees with a fixed office location pay the regional minimum wage rate applicable to the location where an employee works on site at least 50% of the pay period. Now, employees who work less than 50% of the pay period at the employer's fixed location need not be paid the rate applicable to the region where they are working remotely. So picture a scenario where, for example, if I have my office that I typically work out of in Portland, but I live in Salem, and I commute back and forth every day. If all of a sudden I'm not coming into the office in Portland every day, or vice versa, and I'm in a different region with a different applicable wage rate, if something's higher or lower, it's going to affect the way that you pay people. It may end up in you overpaying them, but worse, right? It ends up in you underpaying them, and then ultimately you're on the hook for unpaid wages or unpaid overtime, attorney's fees, all these things that I really, really want to avoid. So it's important if you have telework arrangements to actually know where people are working from if they are non-exempt employees that are being paid by the hour. Next, a remote work policy should define the workspace so that the employer can avoid the risk of an employee just working anywhere. This is really important for workers' comp purposes specifically, right? Workers' compensation laws only cover inquiries in places where employees are expected to be. So we need to, and we can do this via an agreement, and I'm going to show you sort of what the agreement looks like. We can confine the workspace and the work environment so that we on the back end have a better argument with respect to compensability on a claim if there's something that's completely unrelated to the work or the work duties, the job duties, and again, this is assuming that we don't have some major crazy change where we have this presumption of workers' comp compensability for any injury anywhere related to COVID-19. We're going to be able to confine that space so that if, for example, someone's out walking their dog, but they're in other words, teleworking and they trip and fall, we're not going to have a workers' comp issue, hopefully, but if there is a workers' comp issue, there's a much better argument on the back end of that with respect to the compensability of that injury. Before we get to the example, a couple notes on security considerations. This is becoming a bigger deal just because more hacking is going on in general. I don't know, sort of, I would anticipate for the foreseeable future that the amount of attempts at hacking and system overrides and things like those are just going to increase. There's people who do it, and the only thing that we can really do is to educate and train employees and to make sure that our information technology procedures are where they need to be in terms of security. So the first thing with respect to telecommuting and security considerations, we want to educate and train employees on what it means to be secure and to hopefully be in a secure environment, right? This is very industry specific as well. For example, as an attorney, I have certain privilege and confidentiality considerations at home, right, that may be more complicated because I'm at home as opposed to being in a more private setting in the office, right? What are some things specifically related to your work environment where if you have people working from home, you want to make sure that they're still maintaining privacy, confidentiality, and all of those things. Those are considerations, right? Second, you should prohibit employees from leaving devices in cars, hotel rooms, etc. This is nothing specifically related to COVID-19. This is just a generally good principle, right? We don't want people leaving company-issued laptops in the back of their car where they get stolen because there's proprietary information on those laptops that if someone gets a hold of them, we're probably in trouble, right? With that said, we want to have the ability, if something does get stolen, to remotely wipe systems. And I know this is dependent upon sort of what your capacity, your individual capacity at your workplace is with respect to information technology, but really ideally we would have someone that would be able to remotely wipe any systems. So if I'm giving company-issued phones, if I'm giving company-issued laptops, if my laptop gets stolen out of my car, ideally it should be as easy as right when I realize that's stolen, I get a hold of our IT people and they remotely wipe every piece of everything that's on that computer. You may not get the physical computer back, but what is more valuable almost all of the time is the information that's contained on that computer. Another way that we can do that is through password security, right? So even if we weren't able to remotely wipe it and someone got a hold of it, hopefully they still wouldn't be able to access the device because there's some sort of password protection on there. There's some pretty good, and it's worth an easy Google search on sort of what is the best way to create a password in terms of numbers and letters and uppercase and lowercase and all those things. And you really should be changing it every few months as well. But those are some key considerations there with respect to making sure that to the extent we have company equipment out of the office, which means that information is sort of floating, that we're protecting all of that to the extent possible. Okay, one more note on workers' comp stuff, right? workplace injuries are compensable wherever the employee's workplace is located. So this isn't to say that technically, if someone has an accident at home that's related to work, if they're working, and this is within the scope of their employment, they would not have some argument that that injury should otherwise be compensable through workers' comp. But the remote work policy should define the workspace so that the employer can avoid risks of an employee just working anywhere. We want to really confine that space, and this is really an incentive to create individual policies to the extent that you can for individual employees, because people are going to have different home work environments in different spaces. But it's something that you definitely, from a liability perspective, need to be considering. Okay, so I wanted to go through an example policy here for you, and this is going to be provided to you as a Word document so that you can go in and customize it, tweak it, insert information, delete things that you don't think are applicable, etc. Your policy does not necessarily have to be as long as this, but I certainly wanted to provide as much information as possible so that you could condense it as opposed to not having access to things that you would otherwise like to have, right? So there's different categories of things on here, but what you'll notice is this is not sort of your typical traditional handbook provision where we have a paragraph that says, if you want to work from home, call your manager and get approval. That used to fly. I wouldn't recommend it anymore. What I'd recommend is something more comprehensive like this, for the reasons that we've talked about with respect to security, limiting workers' comp liability, all those things. All right, so there's different categories on here. The COVID-19 aspect of it, and this can be removed perhaps at some later date, but I think it's important with every policy to have, okay, what is the overarching purpose here, right? So this first paragraph here where we're talking about purpose is that, hey, given some of the complications and these issues that have arisen as a result of COVID-19, we're transitioning to more remote work, right? And this is a good place too to set expectations that, hey, this is a temporary policy that you shouldn't have any expectation is going to continue on into the future, etc. But I think with every policy, it's important to have sort of the purpose in there so that you can explain to employees why you're doing what you're doing. With respect to eligibility, is it going to be everyone that's able to work from home? Is it going to be a category of people? Is it going to be by job description, etc.? In most work environments, you have probably a category of people who can definitely do their job from home, a category of people who think they can do their job from home, but they can't, and then a category of people who definitely can't do their job from home, right? The policy should set out what the expectations are, and if you even want to say, hey, this is on a case-by-case basis, here's how you can apply and be approved for a work-from-home accommodation, that's fine too. But what we don't want to do is sort of start applying it in a disparate manner where someone can say, hey, you allowed the 3 men to work from home, you didn't allow the 3 women to work from home. That can't happen, right? It's an adverse, it would qualify almost surely as an adverse employment action and disparate treatment within the workplace. We want to have a policy in place that's consistent with respect to our eligibility requirements. Approval. Maybe you have an approval process, maybe you don't. Maybe it's as simple as if you request one, we approve it. I wouldn't recommend that. I would have an approval process where an employee says, hey, I'm working from home for these reasons. One of the reasons you probably want some sort of application and approval process is because that gives you the opportunity to gather some of the information that we talked about earlier. Is the reason this person wants to work from home because they have an absence that's otherwise qualifying under the ADA or under FFCRA? The more we get in terms of that information from them and why they're requiring a work from home accommodation, the better. However, if you've made a decision that you want everyone to work from home, you don't need an application process, right? So again, you can pick and choose some of this stuff as it relates or is germane to your particular workplace. Next, we'll talk about work schedule requirements. This again is up to you, right? Some people are more flexible than others about when you need to be working and when you can't be working. Do you want to have as part of that, hey, our expectation, just as if you were here in the office, is that you're in wherever your chair is at home working by 8 p.m. and that you're going to work till 5 p.m., etc. You can set those expectations. What I will say, though, is to avoid any sort of wage and hour issues, which, as I mentioned, is one of these big key things that I always want to avoid. If you have a non-exempt employee who's working from home, that doesn't mean that the breaks and the lunches and all that stuff go out the window, right? All of that stuff still applies. That person is still going to be allowed to take their breaks. They're going to be entitled to meal periods, all that stuff, right? So customize that so that you have in writing what exactly the expectations are. Next, home office, right? What is the space going to look like? What are we confining the space to be, or what the expectation is, right? This is going to help us from a workers' comp perspective because we're going to be able to confine the work environment. And again, it's not going to stop someone from bringing a claim and saying, I think this is compensable. But what it is going to help is the argument on the back end that it is not, in fact, a compensable injury because it was outside the scope of your work duties and you weren't in the confined workspace that you were approved to work in. Next provision speaks to confidentiality, right? What are some of the work-specific confidentiality expectations that we have in place? If there is nothing in particular, I would probably make it mirror anything that you have in your handbook that speaks to confidentiality. If you don't have a confidentiality provision in a handbook or otherwise, I'd recommend that you get one. Give me a call or an email. We can figure something out in terms of getting you a confidentiality provision. But really, the extent of it doesn't have to be super lengthy, right? Usually, it's going to say something along the lines of, you, the employee, have an affirmative duty to protect confidential or proprietary information that you obtain within the scope of your employment with the company. You have a duty, even post-employment, to maintain the confidentiality and of these things, right? Everyone has proprietary business information. It doesn't mean it's, rocket science or a code that's being protected by, some sort of patent, but everyone has information that's proprietary or that they consider confidential. So you need sort of one of those provisions in there. I'd reiterate it in this policy, but if you don't have it in the normal policy, would recommend that as well. We talked a little bit about workers' comp. We reiterate it sort of in this particular policy. I want you to note that employees still remain at will. Right, in the state of Oregon, employees are considered to be at will unless there is some independent employment contract. If I had an employment contract that said I'm not an at-will employee and I can only be terminated for cause, for example, I'm no longer at will. But absent some independent contractual provision that eliminates the at-will nature of the employment relationship, my employment is going to be at will, and we want to, let people know that this doesn't change that at all. And last but not least, liability. This is sort of my go-to for policy violations, and this, of course, is a policy. Violations of this policy may result in discipline up to and including termination. That's your go-to phrase for this and everything else, right? It leaves you a little leeway saying, hey, it doesn't mean you will be terminated for violations of this. But if you violate this, it may lead to discipline and it may lead to termination. We don't want to have any policy in place that doesn't necessarily have some sort of recourse or consequences, because what would be the point of the policy? Okay, so that's my sort of piece on telecommuting. It's becoming a much bigger issue than it used to be. Again, used to be a paragraph policy. Now we want something more expansive that includes sort of some liability protections, but also a document that's setting forth our expectations for employees who are working remotely. All right, so we're going to talk a little bit about Form I-9s, and this is another one of those topics that frankly is overlooked quite a bit in terms of the, passive nature of it. It's something that's done at the very beginning of employment and is not necessarily thought of ever again, but it really is important because we don't get Form I-9s right, it's a problem. So we're going to run through this material fairly quickly, but there's a handful of different things that I want to hit on this that I want you to think about and consider. So, with respect to current Form I-9 considerations, right, and this is post-lockdown rehiring, we covered a little bit of this last time. You have to review your Form I-9s for employees to be rehired, right? You have to do it. One of the keys to having any employee as an employer is that they have to have a legitimate Form I-9 on file. Review those Form I-9s for people that you're bringing back. Fill out new ones for for people that you're rehiring. If the Form I-9 has been completed within the last 3 years, you don't need to do a whole new Form I-9. All you have to do is go to Section 3. Simply provide the employee's rehire date and sign and date the form. It's as easy as that. This right now is a good time for you generally to pull all the Form I-9s that you have. Think about people that you're rehiring, yes, but also go through to review any existing Form I-9s to see if you have any substantive or technical errors, right? We're going to talk about the difference between substantive and technical errors. The point being, though, the USCIS is conducting notices of inspection and audits into people's Form I-9s to ensure that they're actually checking employment authorization paperwork correctly and that they have people who are eligible to work in the United States, okay? So a couple of the basics here, right? Employers must complete the Form I-9, we know that. Employers may use the federal e-verification process. In fact, I would encourage it to the extent that you can. It's very easy to use, and if the e-verify system screws up on something, at least you kind of have that to fall back on, right? So if e-verify says, hey, this person is good to go in terms of work authorization, and it turns out they're not, at least at some later date we can go to the USCIS in the event of a notice of inspection and say, hey, this was run through your system and it came up as approved, so what was I supposed to do? Timing is another key consideration here, right? So the Form I-9 has to be completed no earlier than the acceptance of the job offer, but within 3 business days of hire. Ideally, you have an onboarding meeting, right, where maybe you hand over the employee handbook, but this person comes in to sign all their hire paperwork. So maybe the initial handbooks, things like that, but they present employment verification. So the most common form of employment verification for United States citizens is your passport, because there's 2 things that are approved on a Form I-9, or 2 pieces of necessary information. One is proof of your identity, and one is proof of your authorization to work in the United States. So there's different things, and we'll talk a little bit about this. There are different pieces of documents that you can provide to satisfy those requirements. The most common one, though, is the passport, because it meets both requirements. It serves as proof of identification, and it also serves as proof of work authorization. Okay, the reason this is an issue, right? There's a huge I-9 problem right now, and this is a result of increases in ICE audits and notices of inspection. This is exactly what happens with a notice of inspection, and it's not fun. You get a notice in the mail that essentially says, hey, the USCIS is conducting this is a notice of inspection, and we want to see all of your Form I-9s within 48 hours. Send them to us, we want to inspect them. They can also ask for additional information. They can ask for your governing documents. They can ask for whatever they want, really. They send you a request for information. You have to send it back within a very short period of time, and then they go through and audit that information. So there's different violations that they're looking for, right? One are what we call sort of technical violations, which are very, very easy things to miss, and also really easy things to fix if you know what you're doing. We're going to talk about how to easily fix those. But technical violations are, for example, I write in a U.S. information regarding a U.S. passport, and there's a box on the form that essentially asks the country of origin for the passport. So you might otherwise be able to tell that this is, a U.S. passport, but if you forget to write in United States or USA, that's technically a violation because you're forgetting to fill in information that is otherwise there. Those aren't as big of a deal. They can still be, subjected to liability if there's, tons of them. However, the more likely outcome there is that USCIS sends you these things back and say, hey, we found X amount of technical errors, and then they give you an opportunity to fix them. Where the big issues are substantive errors. Substantive errors most of the time take the form of false employment verification, right? Someone provides a fake passport, a fake ID, etc. The easiest way that this is caught is that the Social Security number that's submitted on the Form I-9, for example, does not match a valid Social Security number that the United States government has in their system. And what will happen is they send back and say, hey, their Social Security number or identification discrepancies, work authorization discrepancies for these 10 people, these are the Social Security numbers you gave us, right? What happened here? And then you essentially have to go back and talk with employees and figure out, hey, did you give me the wrong document? Was this fake? It's a lot, right? But that's what happens in these inspections, and they're becoming more and more and more common. There's never been a time when these have been done at a higher rate. I don't know if in the last few months, given the COVID situation, if they've slowed down, but prior to that, they were being done at a fairly alarming rate, frankly. The best way to avoid some of these technical violations, there's not a ton that you can do on the substantive violations, but the best way to avoid some of these easy technical violations, like I forgot to check a box, is to perform an internal audit, and now is a great time to do it if you're rehiring people. So here's how you perform an internal audit. I've done tons of internal audits for people, but if you just sort of know what you're doing, you don't necessarily need me. You can figure it out all on your own. So I'm going to try and teach you here how to do it, right? Here's a step-by-step. Gather all of the existing Form I-9 documentation you have, and then go through the USCIS. If you just Google Form I-9s and get on the website there are plenty of examples of Form I-9s that are perfectly filled out. Get familiar with one of those that is perfectly filled out. Use that up against the Form I-9s that you have and go through and see if there's information missing, right? You're going to see easy mistakes. For example, I forgot to write in USA here. This is missing on this document, right? You're going to start, once you get familiar with how one is perfectly done, you're going to start to be able to easily recognize errors on there that can be fixed. So that first step, right, after you gather existing documentation, is to identify the missing or incorrect information. The next step is to make amendments to the issues that you identify. And now, rightfully so, you're wondering, how do I properly make amendments and revisions consistent with what ICE and the USCIS, et cetera, are asking me to do? Here's the great part. Making these corrections is extremely easy. Extremely easy, and here's how you do it. Section 1 corrections have to be made by the employee. So we need to distinguish just for a second. The Section 1 is supposed to be filled out by the employee or a translator. Section 2 needs to be filled out by the employer or a translator. If there are corrections being made, those need to be made by the particular individual where there's missing information. So if there's missing information in Section 1, you need to call in that employee, have them fill in that missing information, right? If there's something that's written there but it's incorrect and you need to fix it, all you need to do is cross out the incorrect information, write in the correct information, and then initial and date the form. So once you make those revisions, right, say I'm missing one thing in Section 1 and 2 items in Section 2, I have my employee come in, we clear up the issue in Section 1, that's signed and initialed, we clear up the 2 items in Section 2, that's signed and initialed. I just write on a piece of paper, on June 11th, 2020, I was performing an internal audit of my Form I-9s consistent with USCIS specifications and guidelines. We noticed 3 small errors on the Form I-9. We corrected them as of today. Sign, date, thank you very much. That's it. That's literally it. That's all you have to do. You attach that piece of paper, staple it right there onto the back of the Form I-9, put it back in the pile. If there are so many mistakes on there that you just need to do a new one, that's okay too, right? What we don't want is a Form I-9 that is completely illegible and you just got lines through this and lines through that. If it's so much to where it's just probably better and more clear to do a new one, fill out a new one. Okay, that's going to be acceptable too, except we don't want to be re-verifying United States citizens or people that we don't have reason to be re-verifying their employment verification. We want to stay away from that. However, to the extent you need to fill out a new form for clarity, we also want to attach that description. So even if I fill out a new form, I want to write out, hey, here's what I did and why. But people, for a lot of reasons, understandably so, they're hesitant to say, hey, I missed this and I corrected it, because they don't want to admit that they made a mistake, and I don't want people to hesitate on that at all. What they want to see is that, hey, you were being proactive about looking over your Form I-9s to make sure they were in compliance. And if you said, hey, I missed this, a year ago, my bad, it's fixed. Okay, they love to see that. So I would not worry about admitting to mistakes, and it's actually going to help you quite a bit. Okay, so same here. Section 2, the only difference between the Section 1 and Section 2 stuff, you're fixing it the same way, but Section 2 is the employer section, right? So I, or whoever's in charge, right, am fixing the information, signing, dating it, attaching the form, to whereas the Section 1 corrections really should be made by the employee, need to be made by the employee. But everything else is the same, right? We just need to fix this, sign it, initial it, slap that piece of paper on the back that's explaining what we did and why. Okay, couple keys just to remember here, winding down on the Form I-9 stuff. The Form I-9 changes all the time. I actually don't know why, because there's not a lot of substantive revisions to it. Sometimes the form just is, looks more concise, or they just put out new versions of the form that aren't really substantively different, but it's a new version. And the only reason that matters is that you're expected to use the newest version of the form for new people that you hire. So if I had an employee that I hired, 2 months ago, and a new Form I-9 came out today, I certainly don't need to go back and get a new Form I-9 with a new form for that person that I hired. But if I hire someone tomorrow, I would be expected to use the newest version of the Form I-9 available, right? So if it came out today, I'm hiring someone tomorrow, I need to use that newest version of the Form I-9. Make sure that you're filling it out entirely. Again, there's a lot of boxes. It's not a very long form, but there's a lot of boxes. So, be careful with going through it, making sure that you're checking the boxes and doing what you need to do. Ensure that the documentation that you're using for verification purposes is documentation that's expressly acceptable as a List A and List B documents. Again, what we're looking for in terms of verification are 2 things. 1, ID, who am I? And 2, do I have authorization to work in the United States, right? You can do a few things in combination with each other. For example, I could submit my driver's license and my social security number. I could use my passport, etc. If we have foreign workers with foreign visas, they're going to submit some form of identification. For example, a foreign driver's license or a foreign passport, something like that. That has to be supplemented with a work authorization document that's acceptable as well. So if you go on, or just Google it really, acceptable List A and List B documents, the USCIS has a really nice form printout that, even with pictures, and this goes across different countries and things like that, and this will be more important for educational institutions and some other places that have a lot of employees that might be coming in as visiting professors or on temporary visas and things like those. What they have compiled are literally examples of different countries' ID cards and things like that, so that you can match up like if it looks real or if it doesn't, right? Some of them are easier to spot than others, and I think one thing that's important to note here, the federal government is not expecting you to be an expert on identification. What they are expecting you to do is to not accept things that are clearly fake, right? If someone submits, an ID card, with the name McLovin on it from some random state that doesn't exist, and you accept it as an acceptable List A document, that's probably not going to be acceptable, right? But if you get caught with something that's completely legitimate, that looks like a normal ID, you're likely not going to get penalized for not having some, scanner that's essentially saying, hey, this is legit or this is not. So the point being there, use common sense with the identification procedures. USCIS is a really nice document printout that will help guide you through that. That's it for today. So we talked about telework policies. We talked about some more comprehensive stuff on the Form I-9s, which are important with the onboarding process. I think the most critical thing, right, some of these things are more common sense than we think that they are in terms of just being smart, sending people who don't feel well home. Some of them are more complicated, right? Some of these disability accommodations, discrimination-related issues, these are things that we really need to be thinking critically about before we take action or make decisions, because in the long term, that's going to help not only keep our employees safe, our customers safe, but it's going to help us from a legal liability standpoint as well. If there's ever any questions, as always, my contact information is here. I appreciate you turning in. Stay healthy, stay safe, and take care.